Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumila Matez. The South African legal system is a blend of British common law, Dutch Roman law, and customary law, reflective of its colonial history. More courts follow South African common law, but will apply customary law when it is appropriate to do so. The head of the South African Judiciary is the Chief Justice of the Republic of South Africa, and Section 8 of the Superior Courts Act provides that the Chief Justice is responsible for the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts, and enjoins the Chief Justice to issue written protocols or directives to give guidance or advice to judicial officers. The norms and standards are binding on all judicial officers and apply to all courts in the Republic of South Africa. The question is whether these norms and standards are going to lead to universal access to justice and efficiency of the courts remains to be seen. This is Rights and Recourse. But before we tackle this subject, let us take a look at this background report.
The Constitutional Court was established in 1994 following South Africa's first democratic elections. The court is representative of South Africa's diverse population and untainted by the past that was established to protect, interpret and enforce the Constitution. The Constitution is the supreme law of the land. It contains a Bill of Rights that enshrines the fundamental human rights of all people in the country. The Constitution also divides the powers and functions of government between the legislature, the executive and the judiciary, and between the local, provincial and national spheres of government. No other law may conflict with it, and all organs of state are bound by it and are obliged to respect, protect, promote and fulfill the rights it enshrines. The Constitutional Court is the highest court in the country. The court hears appeals, directs applications, confirmation proceedings, where a lower court has declared legislation invalid, and may review bills of parliament.
No way can the story of our hectic past and its historical transition to democracy be told other than being at the Constitutional Hill. Many of our political icons such as Nelson Mandela and Mahatma Gandhi were once detained here. What was once a place of injustice and brutality has now been transformed to a place of solidarity and democracy. We are delighted to have Chief Justice Mogoeng with our presenter Dumile Mateza in the studio, and let us hear what he has to say about this historical heritage site.
Thank you, Bali. Chief Justice, good afternoon and welcome to Rights and Recourse.
Good afternoon, Mr. Mateza, and good afternoon to your viewers too.
We went out to ordinary people and asked them whether they knew who the Chief Justice of the Republic of South Africa is. And probably for the benefit of those who do not know, who is Justice Mogoeng?
Well, a man from very humble beginnings in a village called Kofikral, somewhere in the Northwest Province, the Platinum Province, who grew up under very difficult circumstances, with very little resources available to even dream of completing matric. We're very grateful that South Africa is a land of many opportunities. Here I am, having gone through university, having practiced law, having been a judge. This is my 17th year as a judge, by the way. So that's just about who I am, passionate about ensuring that the injustices that our people have suffered over the centuries are put to rest now that I have the opportunity to make a difference.
Well, yes, let's hear some of those people. We asked whether they knew who the Chief Justice of the Republic of South Africa is.
Do you know the Chief Justice?
Chief Justice, no.
No, I don't.
Yes, I do.
Yes, I've heard, but I'm not quite sure.
Do you know where is the Constitutional Court?
Constitutional Court. Is it Cape Town?
Wow.
I think it's around here. I'm not sure about the street. It's around town, Josie.
It's in Small and Pritchard Street.
Just here. Okay, yes.
Just here.
Here we are.
Constitutional Court.
Yes.
Okay.
It's Ibramfontein.
Do you know the Chief Justice?
I know that it's Mukhweng.
I don't know what he does.
Like we said, he holds the office of the Chief Justice.
The Chief Justice is the one who is regarding the judges, who is in charge of the judges and everything, the courts.
I guess he has to ensure that the Constitution is properly followed and that all the rules of the country are fair to everyone.
Well, those are some of the comments we got from people around Johannesburg. Some of them knew the Chief Justice, and some say they're guarding the judges. Is that the real work of a Chief Justice, guarding the judges?
No. It is working with judges and magistrates, and obviously also the organized profession and other key role players in the broader justice system.
The question, in our introduction, we spoke about South Africa is a combination of British common law and Roman Dutch law. Why are we still using Roman Dutch law?
You know, it never really helps to reinvent the wheel. When South Africa became a constitutional democracy, we had a fairly sound legal system in place requiring the Constitution to guide the direction in which it must go and the way in which it must be refashioned. And because we didn't want to reinvent the rules, all we did was bring the Constitution with the fundamental rights in place and make sure that only those laws that are found to be inconsistent with our constitutional provisions are set aside. So that's where we are. Those aspects of the Roman Dutch law that have enriched our legal system, those aspects of our common law and even customary law that have been of great assistance and value to our system are in place, and it is only those that are not in accord with our constitutional provisions that would be set aside.
Now that you mentioned customary law, how does it fit into the South African Constitution?
Well, the Constitution guarantees the existence of customary law. Sadly, South Africans included, do not seem to have much regard for customary law. I think members of the academia and legal practitioners would do this country a world of good by doing more research into customary law and harness those aspects of it that have really benefited African people over the years, such as restorative justice, and educate the broader public and even the broader legal fraternity about the treasures that are to be found in customary law.
The other question I wanted to ask, now that you say you are in charge of judges and magistrates, does this do, the Office of the Chief Justice, does it do away with the Magistrates Commission?
No. You see, the Magistrates Commission is the equivalent of the Judicial Service Commission, which serves the magistracy. It is charged with the responsibility to advertise vacancies, vacant judicial posts for the magistracy, to interview candidates, recommend them for appointment, and it is also charged with the responsibility to take such disciplinary measures as may be necessary against magistrates allegedly involved in acts of misconduct. And that is essentially what the Judicial Service Commission does in relation to judges.
Now that you've mentioned, Chief Justice, the Judicial Services Commission, what is its function?
Well, the Judicial Service Commission, as I hinted with reference to the Magistrates Commission, advertises such vacancies as may exist, and make sure that there is a sifting process through which whoever may have applied go through, and those that are found to be suitably qualified to warrant being interviewed by the Judicial Service Commission are then brought before the Judicial Service Commission for interview. We interview them, we deliberate, then we recommend those that we find to be fit and proper in our view for appointment to the President.
Well, Chief Justice, thank you very much so far. If you'd like to join us on today's discussion, please call us on 011 714 6919 or 18 or tweet us at Recourse. We'll be back after the break. Welcome back to Recourse. As we said, if you'd like to be part of the discussion, you can call us on 011 714 6918 or 6919 or tweet us on Recourse. Mr. Chief Justice, the promulgation of the Superior Court's bill, why was it necessary to promulgate the Superior Court's bill? Was there a gap in the administration of justice?
Well, the Constitution envisages the rationalization of courts. And you would recall that both the 17th Constitution Amendment Act and the Superior Courts Act, as it is now an act, have been a subject matter of discussion for many years, probably 14, 17 years. So it has always been necessary to make sure that the many legislations in terms of which the superior courts in particular are administered are rationalized so that we have one or few pieces of legislation in terms of which these courts are managed. And that's where the Superior Courts Act comes in. So there was that lack of coordination, which did not augur well for the single judiciary that we are, and that explains why the Superior Courts Act came in.
In fact, I'm sorry to interrupt you. In fact, in the preamble, it says, it speaks about the inheritance of a new democratic dispensation of a fragmented court structure and infrastructure.
That is correct. If you look, for instance, at the Eastern Cape, you would realize that you had the Grahamstown Court, the East London Court, you still had the Bishop Court, you had the Mthatha Court. But also if you look at the Northwest, for instance, you would realize that part of the jurisdiction in the Northwest resides under the High Court in Pretoria, and it was for that reason that rationalization also had to set in.
I just want to find out where you say the High Court in Mafikeng resides under the High Court in Pretoria. In other words,
some of the areas, Klerksdorp, Potchefstroom, what is this dam closer to Pretoria? Hartbeespoort Dam. Those are some of the jurisdictions which are within the Northwest Province, and yet the court in the Northwest, the High Court in the Northwest, does not have jurisdiction over them. And that only became possible as a result of the enactment of the Superior Courts Act.
What are the objectives of the norms and standards issued by the Office of the Chief Justice?
Very much in line with Section 165(6) of the Constitution, which was brought into being through the 17th Constitution Amendment Act, with effect from the 23rd of August last year, and also in line with the Superior Courts Act 10 of 2013. The objective was to make sure that the courts, the functioning of the courts is facilitated through the norms and standards. You are able to inject a measure of efficiency and effectiveness in the court system because, as you know, the public has been complaining over the years about the inordinate delays in the court system, cases that sometimes takes up to 6 and even more years to be finalized, sometimes in circumstances where all the evidence you need, all the witnesses you need are available. The many postponements that have been taking place, judgments that are reserved, and people have to wait for rather too long before judgment could be delivered. You needed a mechanism in terms of which a vision geared at ensuring that there is efficiency and effectiveness in the court system, and that cases are, all things considered, finalized expeditiously without compromising the quality of justice becomes a reality in our system. But also to introduce a case management system that would facilitate all this. So that's the objective sought to be realized through the norms and standards.
Now that you mention judgments have to be done, written and delivered expeditiously, we are still waiting for a number of judgments to be delivered.
And it's precisely because the people of South Africa have been complaining about these kind of problems that the lawmakers, in collaboration with the executive, have deemed it necessary to capacitate the Chief Justice by, one, in terms of the Constitution, formalizing his position or her position as the head of the entire judiciary and tasking him or her with the responsibility to establish, but not only establish, but also monitor norms and standards relating to the functioning of all the courts in this country.
It means, therefore, that the budget for the administration of justice will resort under the Chief Justice's office.
Well, it means that ideally,
the budget should be...
The budget for those functions that are central to the operations of the courts ought to resort under the judiciary. And it's a matter that is a subject matter of discussion between the judiciary and the executive now. But I need to hasten to add that a lot of progress has been made, by the way. The very existence of the Office of the Chief Justice, with the progress that has been made in terms of filling in key posts, and added to that, the proposal that we have already submitted to the executive in relation to the ideal model of court administration that are courts with our constitutional provisions. All that points to the fact that in the future we will have the kind of court administration that has got the budget that it ought to have resorting under the judiciary.
The question I wanted to ask, does it then mean that, probably I should go to this question, the presentation you made on the promotion of democracy and constitutional justice, you are quoted as saying, the central features of a constitutional democracy, the right to life, the right to equality, the freedom of religion, the freedom of assembly, universal suffrage, the right to dignity, freedom of expression, which extend to the media and other outlets, how can these be preserved through the Constitution?
Well, you would recall that all these are to be found in the Bill of Rights, and that's Chapter 2 of our Constitution. It is therefore the responsibility of the courts and all those who are given the power by the Constitution to give practical expression to these constitutional responsibilities, these constitutional rights, to ensure that these rights are enjoyed, and for the courts, when disputes are submitted to them for adjudication, to ensure that the outcome is in line with that which would give expression to the rights of the people. So the Chapter 9 institutions as well, they've got a responsibility to make sure that these rights are given practical expression to. So is Parliament, by the way, and the executive.
Are these norms universally accepted by the judiciary?
Well, on the 13th of February 2014, after we had given all the courts in this country the opportunity to express their views on the norms and standards, the heads of the superior courts met and overwhelmingly adopted the norms and standards. And the next day, the 14th of February 2014, I had a meeting with the leadership of the national leadership of the magistracy, and they unanimously adopted the norms and standards. And the 28th of February, which was last week Friday, they were gazetted. So they are operational as we speak now. But like any other thing, you will always have dissenting voices. In fact, I'm not aware of anything in particular that humanity is agreed on that it is the right thing to do. Some believe water is good, others think something else is much better than water.
The other thing I wanted to ask you is there are two areas of distinction that the norms addresses. One is efficiency of the courts, the efficiency of the courts. The other one is the issues of access to justice and a whole lot of other things that you put. How far are we from implementing these particular ones?
Efficiency or access or both?
Efficiency.
Well, the norms and standards seeks to bring into being a system that gets judges and magistrates involved in the administration of the cases. In other words, subject to the appropriate amendment of the rules, we're going to get to the stage where many jurisdictions that are performing very well now find themselves at, and that is ensuring that a judicial officer does not wait until a day or 2 days before the trial date before they have the documentation necessary for the case. They get involved from the very beginning so as to cut down whatever could have given rise to delays, to avoid the many postponements that we experience. People still saying that the case must be postponed for further investigation, that they were not given the documentation that they ought to have been given, others not being prepared because there is nothing to force them to be prepared. But the early involvement of a judicial officer who will regularly be interacting with the legal representatives to ensure that it's all systems go by the time the matter is heard is going to inject the much needed efficiency and effectiveness. As for access, I think access to justice will be facilitated by the speedy resolution of disputes. One of the things that inhibit access to justice is the exorbitant fees, for instance, that people justifiably or unjustifiably charge. But many South Africans who do not have the resources necessary to cope with the high legal fees would still be able, even from their own pockets, to fund their cases provided the delays are cut out. And once the rules have been amended in such a way as to be user-friendly and a bit more flexible, it will be possible for a person who has never studied the law to read the rules and know exactly what it is that is required of him or her to prosecute his or her case in a court of law. I've seen it happen with absolute ease, for instance, in the United States of America. A person who, a second-year engineering student, running circles with a lawyer and ultimately winning a case. Why? Because the rules were user-friendly and they were able to read the rules and understand them, this legal language reserved only for the lawyers, what did not feature in their rules. So there is so much more, by the way, that needs to be done to inject efficiency and effectiveness in the system. I could go on that, deeper into that, if you need me to, but also on access.
We'll come back to that, Mr. Chief Justice. We are talking to the Chief Justice of the Republic of South Africa. If you'd like to join us in this discussion, please call us on 011 714 6919 or tweet us on Rights Recourse. We'll be back after the break. Welcome back to Rights and Recourse. To be part of the discussion, you can call us on 714-6918 or 6919. It's not every day that we have the Chief Justice with us here on Rights and Recourse. Or you can tweet us, as Jongilizwe Dumehleli says, accepting inquiries, retired judges, how can retired judges be used?
Well, we use retired judges in the South African Judicial Education Institute program. And that is the institute that was established to offer judicial education to serving judges, serving magistrates, as well as aspirant judges and aspirant magistrates. Because of the limited number of judicial officers we have, and because they've got to be attending to their cases, retired judges come in handy to help us drive the educational programs for all judicial officers.
You were asked a question in Stellenbosch on June 25, 2013. There has been transformation in the judiciary since 1994, was the question. Many competent lawyers have been appointed to the Constitutional Court. However, there's another group of equally competent lawyers who have not been appointed. Why were these lawyers not appointed?
Well, they've got to tell me who they are talking about. I mean, whenever I'm asked about the activities of the Judicial Service Commission and a question is raised about people who were not appointed, there's one or two names that always feature. I went to London.
I think we know those names.
I went to London to address a meeting at Chatham House, and two names were mentioned. One was interviewed when my predecessor, Chaskalson, was, in fact, twice. That person featured when Chaskalson was Chief Justice, and the other one twice or thrice when Chaskalson was Chief Justice. And yet an impression is sought to be created that Mogoeng has something against these people. That is why they are not appointed. But just to make the point, like any other job, when you make yourself available for judicial appointment, you don't come there with an entitlement mentality. We're not there to rubber stamp any candidate because some powerful forces, influential people, rich people support the candidate. We cherish our independence as a constitutional structure known as the Judicial Service Commission. We put questions to you, and only when we are satisfied that you should be recommended for appointment by the President, we recommend you. We're not going to have people thrusted upon us so to avoid criticism in the public domain. It's part of the package of being a member of the Judicial Service Commission to be criticized. And we welcome criticism, by the way.
Another question is, the Constitution prescribes a judiciary that is racially and gender representative. There is little agreement on this, and how can this be taken forward? There's little agreement how this should take place.
Well, there'll never be agreement for as long as human beings are different, for as long as our interests are at times divergent, there will never be agreement. But the bottom line is this. Section 174(2) of the Constitution, as you rightly pointed out, makes provision for those charged with the responsibility to interview and recommend for appointment judges to remember that during apartheid, Africans, people of Indian descent, and colored people of color, were not allowed to become judges. Very few women were allowed to be judges. In fact, when South Africa became a democracy, there were only two women on the bench. One in the SCA and the other is Jeanette Traveso in the Western Cape High Court. So we've got to turn the situation around. That's our mandate, nothing to be ashamed of. We've got the responsibility to make sure that South Africa looks like the new South Africa, and we should always guard against the inclination by some to want to suggest to the Judicial Service Commission, now you're going too far. It was never meant to go. We've got to go all the way in recognition of what the Constitution requires of us to do as the Judicial Service Commission.
The other issue I would like to get clarity on is transformation and merit. What is the difference between the two?
There is no difference. The Judicial Service Commission does not exist to recommend for appointment incompetent people who are going to disgrace the judiciary. There's a very honorable profession, and when we go there, we as the Judicial Service Commission want to be proud to have been associated with the appointment of a particular candidate. That is why the requirement of fit and proper is there. It means you must be suitably qualified in terms of your educational qualifications to be appointed a judge, but also, we check on your work ethic. We also entertain representations from members of the public about the kind of character you are. If you're always under the influence of things that you shouldn't be under the influence of, and we get to know of this information, it doesn't matter how good a lawyer you are. We're going to take that into consideration. It may weigh against you. If you are arrogant, we then remember what used to be done to those that were discriminated against during the apartheid era. And some of the arrogance is to be seen in the judgments that we read about, that were written then. We're not going to say because of your forensic skills, it doesn't matter how unfriendly you are likely to be, not only to your colleagues, but also how discourteous you're likely to be to members of the public that you must serve when they come before you having cases, because that can only discredit the system rather than enhance the confidence that we so much need from the public and the international community.
Mr. Chief Justice, let's take a call from Chris from Artersville. Chris, good afternoon.
Molo soja kunjani mfundisi?
Sikhona kunjani Chris?
Yeah, ndifuna ukuthetha no Chief Justice. Tell
Yes.
me, hello, how are you, Chief Justice?
I'm very well, thanks, sir. How are you?
Yeah. I'm okay, I'm not virtual.
Ask your question, Chris.
Artersville, Pretoria. I just want to find out if I'm your deputy right now as a Chief Justice. Don't smile. If I'm a deputy.
Ask your question, Chris. Ask your question.
Yeah. The question is, if I'm your deputy and you happen to be transferred somewhere or you retire, what happened to me today? What is the system? Are they going to put me through to be the Chief Justice?
I don't know whether the Chief Justice had answered that question.
No,
Probably that's a question for the executive or the Minister of Justice.
No, I can't.
But he wants to answer it.
Well, right now I'm on leave, and the law provides that when I'm on leave or when for any reason I cannot perform my duties as Chief Justice, the Deputy Chief Justice takes over as Chief Justice for that period. But that can't be forever. When the vacancy arises, the post must be advertised, and it is the prerogative, the constitutional prerogative of the President to determine who he or she is going to nominate for the position of Chief Justice, and then consultation will then take place with the Judicial Service Commission and those political parties represented in the National Assembly.
Well, they will take calls as we come along. I think you can hold on whilst you go to a break, as we will take more calls after the break. Don't go away. Welcome back. Let's immediately go to the lines. I understand we've got Noel on the line. Noel, good afternoon and welcome to Rights and Recourse. Hello, Noel.
Hello, good afternoon to you and to the Chief Justice. My question is more to do with access to justice. Most of the time you have cases with very powerful companies. They always rush to the security of cost. What can I do as an ordinary man to go around that?
What's your question again? If you have a case with a company that has a great deal of money, they always go to the court. Is that your question?
Yeah, they always ask for security of course.
The security of course. I understand what you mean. Mr. Justice understands very well what you mean.
Well, I'm very loath to provide legal advice because I shouldn't. But I can tell you that when the difficulty arises, it is then open to any member of the public, as it has happened in one of the cases we entertained at the Constitutional Court, to appeal that decision if, say, a high court has taken the decision. And I've seen the Constitutional Court consider favorably some of the issues surrounding security of costs, because as I understand the position, and I'm speaking very broadly, the situation should never arise where people are prevented from exercising their constitutional right to litigate because they don't have money. But similarly, people should not abuse the right they have to litigate by litigating even in circumstances where they ought to know or they know that they have a hopeless case. So there is a balancing case there, a balancing exercise, I beg your pardon.
Well, Arthur Noel, I think your question has been answered. I know very well this case that you're talking about. It's been done a number of times to many people who could not afford the money. The question I have, we have somebody on the line, but let me ask this question first. Despite all of these problems we have spoken about in our courts, South African courts function fairly well. I think the Oscar Pistorius case is a case in point.
Yes. Now, South African courts function very well, but we would want to be counted amongst the best. We owe it to the public as South Africans who are privileged to serve in the judiciary, and it is for this reason that we just never stop looking for ways of improving the efficiency and effectiveness of the broader justice system, by the way.
Sviso from Durban, what is your question? Good afternoon.
Good afternoon to you.
Yes, what's your question, sir?
Thank you for taking my call. I just wanted to find out from Honorable Justice, with the level of illiteracy in South Africa and the fact that a lot of South Africans don't have money, how is it that the judge, or rather the Chief Justice, looking into the fact that a lot of people get a fair chance in court, and also to raise the perception that the courts are only for the rich people who will succeed in whatever litigation that they might have? Thank you.
Well, if Mr. Mateza would allow me, this is one question that I would want to deal with fairly extensively, mindful of time.
No, go ahead, Mr.
For starters, you have Legal Aid South Africa that was established not only to assist those who do not have the resources to prosecute their criminal and civil cases, but conditional upon a particular test being met. They've got to satisfy themselves that truly you don't have the resources to prosecute your own case. That's the first point. The second point is there are many bodies out there that litigate on behalf of those who do not have the resources to do so on their behalf. And there are a number of cases that came before the Constitutional Court where people would simply be representing themselves, the papers would not be in order. Under those circumstances, we caused letters to be sent out to the South African Law Society of South Africa, the General Council of the Bar, and institutions like the Legal Resources Center, etc., to inquire whether they would perhaps find it possible to assist. And they have often been able to assist. But more importantly, if you restructure courts like the small claims courts, if you established as many community courts as South Africa requires, if you refashion traditional courts in such a way as to make them constitutionally compliant, then you'll find that most of the cases that people are even going to the magistrates' court for, that people are going to the high courts for, could actually be resolved at that level without spending the kind of money that they are often required to spend. And this is the message that we put across to the National Development Commission, the one that came up with the National Planning Commission, I beg your pardon, when they afforded us the opportunity as the judiciary to make a presentation to them. We say we appreciate that the primary responsibility to bring about changes to the courts as such resides under the executive. But these are the proposals that we put in forward so that as the executive ponders on how best to restructure these courts and to resource them properly for greater efficiency, they can take them into account. We've interacted with the executive about these measures, and I think they would go a long way towards making justice accessible to the many South Africans out there who are even unemployed.
Quickly, Chief Justice, the separation of powers between the executive, the legislature, and the judiciary creates an unenviable tension. It is a feather in the judiciary's cap that it serves as the final arbiter on matters constitutional regarding legislation. Am I right?
No, you're quite right. But that tension is healthy, by the way.
It's a healthy tension.
I'm not aware of any judiciary that is truly independent, that takes decisions that have not resulted in some kind of tension between them and Parliament and the executive. Nobody wants to be overruled, and we often set aside legislation passed by Parliament and provincial legislatures. We often set aside decisions taken by the President and ministers and premiers. That can't be comfortable. Nobody is happy to lose. And that tends to give rise to some tension, but it has been managed so healthily that I don't think it is anything to worry about.
Well, when we come back, I will follow up on that question. There are many people who would like this question to be exhausted around the separation of powers. Don't go away. We'll be back right after this. Through anything. Wow. Let me see. Welcome back to Rights and Recourse as we chat to the Chief Justice of the Republic of South Africa, Honourable Justice Mogoeng. Mr. Chief Justice, there's always been the view that courts cannot substitute a democratically elected legislator, but people continue to resort to courts for relief rather than rely on the legislature, which should be representing their interests.
Well, it is true. Courts cannot substitute the legislature, but it is the responsibility of the courts to resolve such disputes as I refer to them. Sometimes you get a sense that, people resort to courts even in circumstances where a discussion among themselves as politicians would have resulted in an amicable solution of the problem. But when the matter is presented to us, we really are left with very little chance but to deal with the matter like any other case. It demonstrates the confidence that the public has in the judicial system.
In the judiciary. Yes. We have another call on the line. Jacob from Welcome, good afternoon.
Yes, how are you?
Fine, thanks, how are you?
I'm very well. Chief Justice, how are you?
I'm very well, thanks you. How are you, sir?
All right. Speaking to Jacob, actually, Chief Justice, I just wanted to know, as it is known that the 17th Amendment will be making the following changes, that as per Section 167, subsection 3 of the Constitution, the Constitutional Court is the highest court. Previously, it was known as in all constitutional matters, but now it is going to change as it is stated that the Constitutional Court is the highest court of the Republic. And the paragraph I, it stated that the constitutional matters, and previously it was issues connected to the decision of the constitutional matters. I just wanted to know, is this not going to make the Constitutional Court to abuse their constitutional jurisdiction? Because I found the Supreme Court of Appeal.
Jacob, what is your question?
My question is to Chief Justice that is the Constitutional Court is it not going to abuse their powers in terms of giving the authority to make decisions in constitutional matters and other issues?
In other words, you are asking why is the Constitutional Court the apex court in South Africa? That's your question.
Yes.
Well, for the record, the Constitutional Court has been the apex court since the 23rd of August 2013. It's not going to be, it already is. And two, colleagues who serve in the Constitutional Court and in all other courts are men and women of integrity. And it is those who are corrupt who abuse their authority. So we are not, and we are not about to abuse our authority, but just make sure that we act in line with the constitutional provisions.
You made reference earlier to the administration of justice, and the one fundamental thing is the languages used by the court, which you made mention of. But the absence of African languages in our courts, what is happening with this issue?
Well, it's a very hot issue. I remember some years back, it could be 7 years ago, the leadership of the judiciary, of which I was part in my capacity as judge president, set up a committee to come up with proposals on how best to deal with this issue. And even the committee members, though they were 3, they were divided. 2 said we must use all 11 languages as language of record. 1 said it's not feasible. Even the resources do not permit. But it's a matter that, a decision that must be taken by the executive, and we submitted the report to the executive and made the recommendation that I'm not comfortable to disclose. It's for them to decide. But I think practical considerations should feature prominently because we've got language services, interpretation services available to our people.
Let me go back to the callers. We have Eric, also from Welcome. Looks like they're sitting together. Eric, good afternoon. Eric, good afternoon. Is Eric still there? He's gone. Okay. Mr. Chief Justice, the one question I wanted to ask. You have developed a media division and employed a media specialist in your office to deal with queries of the media, of the Fourth Estate. Should we expect regular briefings from the Office of the Chief Justice from time to time?
Well, regular, I wouldn't say, but there would be briefings as and when the need arises. We familiarized ourselves with systems in other jurisdictions. There is a very close working relationship between the media and the judiciary. As a matter of fact, when I was asked by SANEF to go and address them in July 2012, we agreed as a matter of principle that we're going to come together and have a working relationship to the point of even training those court reporters on the language of the court and on how best to report on court matters without missing the correct terminology. Unfortunately, we haven't been able to meet, and I've asked some of the people in the office to facilitate that engagement.
The other question I had was the administration of justice in any democracy is only as strong as its weakest link. I thought you couldn't answer this question, but I think I should ask this question. Despite a strong judiciary, it would seem that South Africa does not have a strong prosecutorial regime. There's a dearth of prosecutors in this country. What can be done to strengthen the link between the prosecutorial regime and administration of justice?
Well, there is a strong prosecuting authority in this country. But because we refuse to be complacent as the broader justice community, what we have done was to set up a committee known as the National Efficiency Enhancement Committee on the 13th of October 2013. No, 2012, I beg your pardon. And we have, during the course of 2013, established its provincial equivalents known as the Provincial Efficiency Enhancement Committees. What they do, we come together, I chair that committee, and say, what are the problems in the broader justice system? The police, represented by the National Commissioner, behind closed doors, we're able to say to them, this is how you are frustrating us. And as the judiciary, we're also able to say to the prosecuting authority, you're lacking in this and the other area. The Legal Aid South Africa, the attorney's profession, the advocate's profession, and they in turn, every key role player is involved there, is represented there. And they in turn are able to say to us, without anybody's independence being compromised, that you judges and magistrates are failing the system in this or the other area. For instance, one of the issues they've complained about in relation to the judiciary are the postponements and some of the delays in delivering judgments that we have touched on. So we have identified key areas, key priority areas that each unit represented in this structure must begin to work on so as to improve efficiency and effectiveness in the broader justice system, including training of personnel and officials.
What is your view, Mr. Chief Justice, about broadcasting court proceedings, not for the spectacle, but also to educate the general public as to how courts function?
Well, impartation of knowledge is key to our democracy. Transparency is key to our democracy. You're probably aware that we allow cameras all the time. We allow journalists all the time as the Constitutional Court. And other courts are beginning to open up as well to allow the media as much access as possible to their proceedings. But all this is done in a manner that is designed to ensure that you do not do harm to the evidence that has been led. Are you going to allow the media to come in when children are testifying? Are you going to allow the media to come in under all circumstances, or should it be controlled? We think under certain circumstances it should be controlled, but generally speaking, access should be allowed.
Among the constitutional requirements for the appointment of judicial officials to the bench is that they should be you've answered this question. I'm sorry, you've answered this question. I always wanted to know what's the meaning of fit and proper.
I've answered the question.
There are people in some circles in the legal fraternity who claim some executive or political manipulation of the Judicial Services Commission. Is that what you perceive the JSC to be?
No. In fact, you'll find that people will never tell you about how America appoints judges. In America, unlike in South Africa, you don't have any judge involved in the process of appointing judges. It is only politicians. And I haven't heard any of the critics of the Judicial Service Commission referring to America, which is probably the world's oldest democracy. Germany, for instance, I interacted with my colleagues in the Constitutional Court there. I said, what is your judicial appointment process? No judge is involved. It is only politicians. Some of these oldest democracies, judges are not involved. Ours is a much more transparent system, which is even opened up to the media. You know, I ask colleagues, and I won't mention the jurisdiction, where there is no politician involved in their judicial appointment process. The media is not allowed there. And even when you want to know why you were not appointed, you are not allowed to have access to the information. So I think, just to wrap it up, I haven't experienced any political manipulation. We get involved in very robust deliberations, and at the end of the day, when we have understood each other, a decision is taken. No political interference.
Mr. Chief Justice, thank you very much for your time.
It's a pleasure.
It is vitally important in a democracy that individual judges and judiciary as a whole are impartial and independent of all external pressures and of each other, so that those who appear before them and wider public can have confidence that their cases will be decided fairly and in accordance with the law. When carrying out their judicial function, they must be free of any improper influence. This has been Recourse. We would like to thank our esteemed guest, the Chief Justice of the Republic of South Africa. From all of us here in the studio, have a good afternoon. You can get information on the Constitutional Court and how to contact them on our website and on our Twitter account. Thank you very much and good afternoon.